The broadcast is now starting. All attendees are in listen-only mode.
Welcome to the webinar on managing the impact of COVID-19 on your agency, presented by Municipal Research and Services Center of Washington. This webinar is presented in partnership with Pacifica Law Group and Summit Law Group. So we've scheduled this webinar for 1 hour today, but it may very well go longer. If you need to leave before we are finished, you can listen to the recorded version, which will be posted on MRSC's website and also emailed to registrants after the webinar. In addition to the PowerPoint, there are several presentation handouts, all of which you can find in the toolbar. And you can submit questions via the toolbar today. We will not be able to respond to the questions during the webinar, but we intend to review those questions after the webinar and identify any frequently asked questions. MRSC consultants will be working to prepare responses to those FAQs and posting them on MRSC's webpage on COVID-19. A link to MRSC's COVID-19 webpage appears at the end of this presentation and can also be found right on our homepage at mrsc.org. Now, if there are any technical difficulties today, remember this is being recorded and it will be provided so you can access it at a later date. This slide outlines MRSC's services. Our mission is to assist local governments across Washington state, and we do this through a variety of methods. In particular, one of the methods is to provide timely news and information like this webinar today. And a legal disclaimer here, the content of this webinar is for informational purposes only and is not intended as legal advice, nor as a substitute for the legal advice of an attorney. You should contact your own legal counsel if you have a question regarding your legal rights or any other legal issues. My name is Flannery Collins. I am the managing attorney at MRSC, and I am very pleased to be joined today by Jamie Lissagore, who's a partner at Pacifica Law Group, as well as Sophia Maybe, who is a partner at Summit Law Group. So the novel coronavirus, or COVID-19, presents a very unique opportunity for MRSC to help our local government customers in Washington state. We've been receiving numerous questions about how local governments should respond to this unique, unprecedented public health emergency. This webinar will not answer all of your questions. It's just not possible to do that today, but we hope it will provide you with a good foundation for moving forward in your agency planning. This is a rapidly evolving situation with increasing restrictions and warnings being imposed by federal, state, and local governments. So it's appropriate then to start this webinar with an overview of emergency powers. What is the federal government's role in this situation? How about the state or the county public health? And last but definitely not least, what authority do cities have? Jamie Lissagore from Pacifica Law Group will handle this part of the webinar. We'll then turn to Sophia Maybe from Summit Law Group to address the impact to government employees, including agency policies on telecommuting, as well as what type of leave should be taken under the various circumstances that will arise during this public health emergency. And then finally, we'll cover remote meetings of the legislative body and how to conduct those meetings properly. So I will now turn it over to Jamie Lissagore to address emergency powers.
Thank you, Flannery and MRSC, for organizing the webinar and inviting me to participate. As Flannery mentioned, I'm going to talk this afternoon about emergency powers. First, we'll walk through the powers and role of the federal government and the state, looking in particular at the governor, the numerous state and local public health entities, and local governments. I'll then mention a few emerging issues, including the potential for conflict between and among all of these public players. And finally, a few resources that I found helpful on this topic. I'd like to add my own disclaimer in addition to the one that Flannery provided. The purpose of the presentation is to provide a framework for understanding emergency powers. I'm highlighting key players and laws, but this is not meant to be comprehensive. I've also summarized laws and court decisions so that we don't get too bogged down in the weeds, but the slides and my comments should not be taken as an authoritative interpretation or as legal advice. This all probably goes without saying, but as these issues come up, you should look at the statutes themselves, and hopefully these slides can provide a useful jumping off point. If you all think back to elementary school civics class, hopefully you'll remember that the federal government has limited powers, only those enumerated in the US Constitution. All other powers are reserved for the state. Under the Constitution, there is no general federal police power, and instead, the federal government's public health powers have to fall within one of the enumerated powers, like interstate commerce or foreign relations. In practice, this means that under normal circumstances, public health matters are generally handled at the state and local level, with the exception of certain federal lands. But in the face of this global pandemic, which has spread across state and international boundaries and has impacted interstate commerce, trade, and national security, just to name a few, the federal government's potential emergency powers are quite broad. Congress has passed a wide range of legislation related to public health, and several that have already come into play during this public health crisis. In late January, the Secretary of Health and Human Services declared a public health emergency under Section 319 of the Public Health Services Act. The declaration triggered emergency powers that allowed DHHS to assist state and local governments in various ways. The Public Health Service Act also grants certain quarantine and isolation powers. These powers include the power to detain, medically examine, and conditionally release people arriving into the United States from abroad. The Act also grants quarantine and isolation powers to prevent the spread of communicable diseases between the states. Notwithstanding this potentially broad authority, according to the CDC, the last time large-scale isolation and quarantine were enforced by the federal government was during the Spanish flu pandemic in 1918. As you probably heard just this past Friday, President Trump declared a national emergency, and in doing so, he invoked two statutes, the Stafford Act and the National Emergencies Act. The Stafford Act is specific to FEMA, the Federal Emergency Management Agency, and it allows FEMA to provide additional resources to help across the country. And importantly, the declaration allows states to request a 75% federal cost share for expenses that are related to mitigation efforts. So if you're spending money responding to the crisis, this is certainly something you'll want to look into to see if it might apply to you. Unlike the Stafford Act, which is focused on FEMA, the National Emergencies Act is a general statute for any type of emergency, and it has been used by presidents over the years to claim more sweeping authority. President Trump's proclamation triggers more than 130 special provisions that range from seizing property and commodities, restricting travel, regulating private enterprise, and even instituting martial law. I could do an entire webinar on this one act, but for now, we'll just note that President Trump has specifically invoked it, and going forward, the act could be relied on as a source of incredibly expansive federal powers. One final federal statute I wanted to note is the Federal Food, Drug, and Cosmetic Act, which authorizes the FDA during a public health emergency to allow the use of unapproved medical products. That can include drugs, vaccines, or diagnostic devices. So that's something to keep in mind as hopefully new technologies emerge in response to this COVID-19 virus. Turning now to the state. So the state enjoys broad police power to protect public health and safety. The Washington Constitution doesn't specifically call out the state's broad police powers, but I've cited a couple of provisions in the Constitution that you can take a look at if you're interested on particular issues. The governor is in charge of the state's emergency response. The Constitution vests the supreme executive power of the state in the governor, and the Washington Supreme Court has acknowledged that the legislature has vested broad emergency powers in the governor through statute. I've cited the key statutory provisions on my slide. They're found in the chapters on the governor and emergency management. As you likely know, Governor Inslee has declared an emergency in all counties in Washington across the state. And by doing this, he triggered emergency powers both for the governor himself and other state and local actors, as we'll discuss. Now, the governor has a vast array of emergency powers. I'd like to just highlight a few. First, the governor can issue emergency orders prohibiting certain activities. The statute lists a number of activities, including, for example, prohibiting people from assembling in public and private places. We know Governor Inslee has done this most recently, I think about an hour ago, by issuing a new proclamation prohibiting gatherings of more than 50 people. There's also a broad catch-all in the statute that allows the governor to prohibit, and I'm going to quote here, such other activities as he or she reasonably believes should be prohibited to help preserve and maintain life, health, property, or the public peace, end quote. So obviously this could be interpreted quite broadly. The governor cited this authority last week when he limited visitation at nursing homes and also waived the state laws that would otherwise guarantee visitation rights to residents at those homes. There's another statute that grants the governor authority to waive and suspend certain types of laws and regulations. This is an important one because just in 2019, the legislature added another broad catch-all provision that allows for the governor to waive any rules and orders of state agencies in a time of emergency with only certain limitations, for example, for the First Amendment. Waiver is limited to 30 days, but then can be extended by the legislature. And the legislature did think about the fact that they're not always in session, which they're not right now. And so these measures, these waivers can be extended by leadership in the House and the Senate during the recess. Turning now to state and local health entities, we have multiple health agencies and boards at the state and local level in Washington. And I found that it's helpful to have at least a basic understanding of these agencies and the roles that they might play in responding to the crisis. Again, this slide is not meant to be comprehensive, and in the interest of keeping within my time limit, I'm just going to provide a couple of key points. First up, the Washington State Board of Health is responsible for statewide public health policy and rulemaking. So for example, the board has adopted rules on quarantine and isolation that I'll talk about a bit later. The Washington Department of Health, in turn, enforces the board's rules. It has the power to investigate outbreaks and epidemics and institute legal proceedings, among other things. One thing of note, the secretary can act in local matters during an emergency, exercising the same authority as local boards of health and local health officers. We have a quite complex system of health entities at the local level. So first up, the local health boards have broad authority to protect the health and life of people within their jurisdiction. The boards are generally organized along county lines. So usually you'll find your board covers one or more counties, and their powers include rulemaking, enforcement of public health statutes and rules, and providing for control and prevention of infectious diseases. There's also a public health officer, and that officer generally acts under the direction of the local health board. We also have local health departments that provide public health services to people in the area, and those can be organized in different ways as well. Where we're streaming from here in Seattle, we have the King County Board of Health, the King County Public Health Officer, and the combined Seattle-King County Health Department. And there are also a few special purpose districts that cover Seattle, including a public health district. If we look solely at the statute, I think it's pretty clear that there's a lot of overlap in the authority granted to local health entities that cover the same geographic territory. And so not surprisingly, in practice, things vary across the state, both in terms of how entities are structured and how their roles are defined. There's a lot of coordination going on right now, but also the possibility for conflict as folks are responding to issues we've never faced before. But more on that later. For now, I'd like to turn to our local health officers and provide a bit more information about them. They have powers that are particularly relevant to this crisis, and they've been very active so far. A few of the powers of note: the officers have a duty to take action to maintain health and sanitation and to control and prevent the spread of contagious diseases. So for example, the King County local health officer has relied on these two powers in requiring protective measures for social gatherings. I believe, at least in the order that was issued before the one today that related to gatherings of above and below 250 people, the officer cited these two powers in issuing that order. You'll, at least with regard to the last set of orders, and I apologize, those new orders just came in, I think, as we were sitting here prepping to go online on this webinar. But at least in the last orders, the King County officer's order was more stringent than the governor's order, so the two were consistent. But if you were under King County, then there were additional public health measures that were in place for gatherings of under 250 people. It's worth noting that there's also a catch-all in the public health officer statute, and so that grants the officer authority to take such other measures as the officer, quote, deems necessary in order to promote public health, end quote. Again, that's a potentially very broad power, especially since courts have typically construed these public health statutes liberally, particularly when dealing with control of contagious diseases. The statute is silent on whether local health officers have authority to waive local laws. The orders issued by local health officers can be mandatory, and a violation of an order is a misdemeanor. The King County order I mentioned is mandatory, but for now my understanding is that officials are encouraging voluntary compliance and providing information and education in response to complaints. The state board has adopted rules for quarantine and isolation, and these procedures are all set out in the WAC. Under those rules, the local, thank you, get us on the right slide. So here we are with quarantine and isolation. Under these rules, the local health officer and the local health officers are responsible for implementation. The officers can issue orders for emergency detention for a person or group of persons, and they can do that without giving prior notice. And then the police and officers of local governments must enforce these orders. People who are subject to mandatory confinement have a right to expedited review by the superior courts and a right to assign counsel. We're already seeing some of the practical difficulties in implementing even voluntary quarantine and isolation, including where to house people. The WAC addresses conditions of confinement where it's mandatory and requires that people's needs must be addressed, including with respect to food, clothing, and shelter. And here's the standard that's in the WAC, quote, to the greatest extent possible in a systematic and competent fashion, end quote. Turning then to local government public health powers, we start with the Washington Constitution, and that grants counties, cities, and towns all local powers not in conflict with the general laws. Washington courts interpret this as an affirmative grant of power, so you don't need to look to a statute. And in general, a county or city can exercise this local power so long as the subject matter is local, the regulation is reasonable, and it's consistent with state law. A range of public health ordinances have been upheld by the courts under this local police power that comes from the Constitution, including regulations on private hospitals and procedures for local quarantines. Beyond this general grant, a key source of local emergency powers is found in the RCW chapter on emergency management. This statute grants counties, cities, and towns power to enter into contracts and incur obligations necessary to combat an emergency, protecting the health and safety of persons and property, and providing emergency assistance to the victims. The statute also allows for flexibility in exercising this emergency authority. So it allows counties and cities to bypass certain time-consuming procedures that are otherwise prescribed by law, so long as they comply with constitutional requirements. This is another example similar to the governor that specifically allows for waiver of laws in response to an emergency. The statute provides examples of the types of requirements that can be waived, including budget law limitations, competitive bidding requirements, employment of temporary workers, levying taxes, and appropriation and expenditure of public funds. You can take a look at the statute for a non-exhaustive list of examples, and there are several more. There are also specific laws on emergency powers scattered throughout the RCWs, including in the various city statutes. And so that's something I know we're all used to in municipal law in Washington, but you'll want to take a look at the statutes that are specific to you to see if there's anything that may be of note. There are special implementation tools that are also available during an emergency. The governor, as well as the counties and cities and towns, are directed to use existing resources from all levels of government, and that includes officers and personnel from other municipal and quasi-municipal corporations. These public officers and personnel are directed to cooperate, and this is a quote, notwithstanding any other provision of law, end quote. As we're seeing, existing resources aren't going to meet all of the needs in responding to this crisis. And so, as I mentioned, emergency powers provide, for example, for hiring additional workers, acquiring property, and buying or renting equipment and supplies. In addition, if needed, the governor and chief executives of counties, cities, and towns have authority to commandeer service and equipment of private citizens. Something I wasn't aware of until just recently. And there are laws that explain how that's supposed to work in the emergency management statute. So that's a snapshot on sources of authority, but of course we can't forget the US and Washington constitutions and the limitations that they place on government authority even during an emergency. For example, the Washington Constitution includes a prohibition on gift of public funds. There's a well-developed body of law on this provision that needs to be taken into consideration as policymakers are coming up with new programs to help public employees and members of the community. For example, this might include paid sick leave for public employees that's not otherwise guaranteed by law or agreement. And I think Sophia is going to say something on that later. Rent or utility abatement and other programs designed to help out the community. There's a lot of flexibility in this area, and so these are things that the government can do. It's an opportunity to be creative and to craft legislation that will stand up to a legal challenge if necessary down the road. From my overview, it should be readily apparent that emergency powers are broad, and there is a lot of potential overlap at each level of government. Things are moving quickly, and as we face entirely new challenges on a daily, if not hourly basis, there really hasn't always been time to sort out clearly defined roles and responsibilities as we normally would through, for example, interlocal agreements, franchises, and the like. There has been a great deal of coordination and cooperation at all levels of government, but some conflict is inevitable. I've included a cite here to a case you may have seen in the news. King County bought a motel, an Econo Lodge in the city of Kent to use for purposes of quarantine and isolation. Relying on its emergency powers, the county has not followed all of the city code requirements that apply to that property. A court commissioner ruled that the county acted within its authority and denied Kent's request for an order blocking the county. But I believe there's a hearing coming up at the end of this week in front of a Superior Court judge to look at this issue. Now, I can't give you a simple answer on how that case is going to come out or on the many other conflicts that are likely to arise. Instead, I'm just going to stress the importance of public officials talking with your lawyers early and often. We may be able to help avoid a legal fight or, at a minimum, put the government in the best position if an issue ends up in court. Finally, as promised, a few resources on emergency powers that I found particularly useful. The court, just in 2017, updated a bench book on public health communicable diseases. It provides a great outline of authority at every level of government, and also a lot of details about mandatory quarantine and isolation if that comes into effect. The Attorney General's office also has a bit of an older memo from 2008 on legal authority for public health emergencies. So hopefully this presentation has provided a framework that you all can use as a jumping off point as the situation continues to evolve. And thank you again for all of your time, and to MRSC for having me.
Great. Thank you so much, Jamie. This is Sophia Maybe with Summit Law Group, and I'm going to jump from that topic over into the employment arena. I'm going to be speaking about the impact of the COVID virus on some employment situations, sending employees home, what are the various forms of leave that are likely to be used under these circumstances, and kind of where we see things going from here. So let's jump in, first of all, to some common questions that we're seeing. First of all, can an employer send an employee home if they display symptoms of COVID-19, or if the employee otherwise poses a direct threat to workplace safety? The answer to that question is a resounding yes. Second, can an employer require the employee to remain symptom-free for a period of time, to submit to a medical exam, or to provide a doctor's note before returning to work? Again, the answer, yes. And the third question here, which is really an important, I think, starting point for all of the rest of these questions and answers, is about relying on guidance and recommendations from the public health officials that Jamie's just been referring to. So can an employer rely on the CDC or local health department recommendations to send employees home? Yes. And really, should the employer do so? Again, yes. We as employers are not necessarily medical officials. We are not going to instinctively know what are the right things to do to make a workplace safe. And we really should and must rely on all of those local health officials and federal CDC recommendations to determine what should be done in the workplace. So then obviously the question then leads to, well, where does this leave an employee? What type of leave should an employee be on? And the answer to that really is going to depend on the circumstances. So let's look at the next slide, which is your starting point, which is all of sort of paid sick leave options available in Washington State. Most public employers are offering some combination of these, starting with the first, which is a mandatory sick leave program for all employees in the state of Washington. This was a initiative-driven law, came into being in 2018. By its own terms, it applies to non-exempt employees. These are your hourly employees eligible for overtime under Washington state law. Folks who fall within that category have the right to accrue state sick leave, and they have the legal right to use state sick leave. And what you're seeing on this slide are really the sort of summary of the uses that are going to be most relevant to the COVID crisis. First of all, a non-exempt employee has a statutory right to take state sick leave for themselves or for a family member who's either mildly or severely ill. So any kind of health condition is enough to trigger use of state sick leave, or even preventative or other medical types of care. In addition to that, this law allows non-exempt staff to take state sick leave if their workplace is closed by a public official for a health-related reason, or if their child's school or place of care is closed for a health-related reason. So because public employees are all working for public officials, when we have public officials closing down public workspaces, the state sick leave program is going to be a source of paid leave for employees to take absences from work and continue to receive their regular wages. According to the State Department of Labor and Industries, it is an individual employee's choice whether or not to use Washington state sick leave. So if I am an employee, my child's school has closed, I could, according to the state, affirmatively decline to use my state sick leave. Presumably, if that's the only option for me to maintain my wages, I would choose to use it. But strictly speaking, according to the state, that has to be a choice. Fortunately, there are often many other forms of paid leave options available apart from state sick leave, one would be any sick leave that's just provided by an employer under the terms of a policy or collective bargaining agreement that is separate from state sick leave. So when the state law went into effect in 2018, some employers decided to segregate Washington state sick leave, which is subject to all the statutory protections, from employer provided sick leave. And you would know that if you were an employee, you would see it on your paycheck. I know how much state sick leave I have, and I know how much other sick leave I have. Whatever is other, whatever is not the state bank is, as I said, going to be driven by and guided and subject to all the rules and provisions of the employer's policy or collective bargaining agreement. And because of that, obviously, those types of leave banks can be modified through employer action. All of those same principles apply to what you're seeing next on the slide here, which is PTO, paid time off, vacation, comp time. Those programs also tend to be driven by employer policy and become a source of wage replacement for someone who's absent. Last on here would be shared or donated sick leave programs. You're seeing the Washington Administrative Code that specifically permits shared sick leave programs. Once a shared sick leave program is in place, according to Washington state sick leave law, that program needs to be accessible for non-exempt employees who would otherwise be eligible to use their own sick leave. So a shared sick leave program would provide a basis for someone who needed to be absent because their child's school was closed. If they ran out of sick leave, they would be able to draw from a shared program. It's also worth noting that employees who donate to a shared pool program can be taxed for that donation, but we are in a situation now where certain IRS exceptions are likely to apply, namely one that's called the Major Disaster Leave Sharing Plan program. I'm going to repeat that. It's called the Major Disaster Leave Sharing, and it is a pool that can be established in a situation that we experiencing today, where a national emergency has been declared by the president, where leave can be donated into a pool and drawn out of that pool, and only the employee who's drawing from the pool is going to be taxed when those wages are paid. The people donating in do not have to be taxed, even though it's drawn out, for example, for a school being closed. So let's go to the next slide. A couple of other family medical leave laws worth keeping in mind. The first is a Washington state law that permits any employee who has accrued paid leave, whether it's vacation, PTO, sick leave, any form of accrued paid leave, they have a statutory right to use that leave, whichever one that they choose, to care for certain family members. So it's a statutory right essentially to access accrued leave that one already has. Notable, it's not for yourself, it's for either your child who has a health condition or a family member with a serious health condition. Apart from that, there are two additional types of family medical leave worth keeping in mind. The first being the new Washington State Paid Family Medical Leave Program. This is a program administered by the Employment Security Department. Employees can apply for benefits to the state and receive essentially a partial wage replacement from the state in the forms of checks coming in the mail. Employees can be eligible if either they or a family member has a serious health condition. There is a 7-day waiting period, so it's not a benefit that can be accessed on the first day of absenteeism, but after 7 days, individuals can apply for benefits. Some employers have allowed their employees to supplement paid family medical leave benefits with their own accrued leave. That is an employer choice, and it really just depends on the employer whether they are permitting that or not. If an employer does not allow supplementation with one's own accrued paid leave, then an employee is in essence on an unpaid leave of absence, but receiving benefits from the state. Last but not least, the one I think everyone has heard of, the FMLA. This is a long-standing federal law that permits employees to take leave of up to 12 weeks for a serious health condition, either of themselves or a family member. Sometimes people are confused that this is another bank. This is not actually a bank of leave. It is a designation, so someone can be on FMLA, and paid family medical leave at the same time. They would be getting benefits from the state, and they would be enjoying the privileges of being on FMLA. So it itself doesn't provide pay. What it does provide is that when an employee is on FMLA, the employer must continue paying the employer portion of that person's health insurance premiums. So it has a notable advantage in that respect. One note I think that's very important is, the COVID-19 virus does have sort of a range, right? It has a mild form and then the much more severe. In its mild form, the virus is going to probably appear to some to be more, right, like a flu type of health condition. And as many of you know, you cannot take FMLA for something like a cold or a flu. It does have to meet the requirements of a serious health condition, which at its most basic under the FMLA would mean you cannot work for more than 3 days and you've seen a doctor, right? You're under a continuing treatment by a medical provider. So you could certainly qualify, but it's not a guarantee. Next slide, please. Couple other forms of leave we want everyone to be aware of. First of all, unemployment insurance. Obviously that's going to apply for someone who's laid off or loses their work hours. What's notable is that the state has been promulgating some emergency rules that would make unemployment insurance available for folks who otherwise wouldn't. And that includes folks who may be mildly ill with the virus, some quarantined workers, and then obviously, if there's closures or reductions in hours, they're going to be looking to grant benefits in those circumstances. There is a link at the end of my charts that I'll point out to you that has a website where there's a chart that does have a reference to those emergency rules, and that can be helpful in consulting to determine what the state is currently offering. I'll note that that chart has gone through a couple of different versions since it was originally posted, so it's important to kind of make sure you're looking at the current version. Second to that, workers' compensation. Clearly anyone who catches the virus or otherwise becomes ill or injured at work is eligible to apply for benefits. The state is also advising us that healthcare workers and first responders under quarantine may also be able to apply for workers' compensation. Apart from these state programs and benefits, many public employers utilize something called paid administrative leave. Paid administrative leave is often used, for example, in a disciplinary proceeding where an individual needs to be removed from the workplace for a period of time while a misconduct allegation is investigated. Sometimes it's also used if an employee there's a question as to whether the employee is fit for duty. So there's practices out there in the public employer environment where paid administrative leave is a way to maintain wages until either discipline is taken or other action to determine if someone has the right to be at work or not. And there may be some public employers who are thinking of or using paid administrative leave as a stopgap now, or thinking of ways to use it to lessen the impacts and to mitigate the harshness of folks being sent home. It's certainly something worth considering. I think as I work through the rest of this slide, we'll kind of come back to whether that's necessary or not, but it is a form of paid leave. And as long as it's being used in the manner in which it's been authorized, then it can provide an additional option. There may be, other than that, other employer policies that are already in existence that could provide guidance as to how wages and benefits should be handled. So if you have an emergency closure policy, it may already be in place, may provide guidance as to how essential and non-essential personnel should be handled in terms of pay. Furloughs and layoffs, those are kind of, again, looking ahead perhaps to some agencies who are really going to be in a difficult position. We saw these during the economic downturn in the past, and we don't know how far things are going to proceed from this point. When it comes to layoffs, it's important to keep in mind that if there's a very large number of employees that could be laid off permanently, that there's a federal law called WARN, W-A-R-N, that requires advance notice, and the notice is a 60-day advance notice requirement. So if you're looking at layoffs that are permanent for a large number of your staff, I think it's 50 or more employees, there's going to be some procedural hoops to jump through, and certainly important to start thinking about that as soon as possible. Paid leave must be authorized by policy or contract to avoid gifting of public funds concerns. So we've seen here all the various programs that exist. You may have an employee in a very difficult position who's a new employee, let's say, and they don't have any accrued leave, or they've had significant health challenges in their career and they just have nothing left in their banks, and the employer wants to do the right thing. There's nothing wrong with doing the right thing. It's just important to remember that in the public sector, any kind of payments, so paid leave, has to be authorized. It has to be done in accordance with some kind of policy or collective bargaining agreement or something that shows that's not a gift. So that's important reminder there. And then finally, I think another reason to sort of pause and be thoughtful about continuing wages and benefits is the federal government is really on the cusp of adopting some kind of temporary wage protection bill. We have the name of it, the Families First Coronavirus Response Act. One of my partners, Kristen Anger, prepared a summary of this bill that is included in this webinar as a handout. And what we're seeing from the bill, which has passed through the House, is it's likely to include some significant new paid leave entitlements for employees in the public sector as well as the private sector. Two notably, one, an expansion of the FMLA, including paid leave for up to 10 weeks. It's at a reduced wage level, so I think it's 2/3 of regular wages, but a huge entitlement to paid leave paid by the employer. In addition to that, 2 weeks of emergency sick leave, again, paid by the employer. And these are on top of any other leaves available to employees. So these are going to, hopefully we'll be seeing more on these in the very near future, but they're likely to provide some additional form of wage replacement. All right, next slide. Okay, so let's say you have an employee, they are not unhealthy, they don't have a family member who's unhealthy, they don't have a child whose school has closed, they don't fit within any of the previously described leave statuses, they're healthy, all respects, and nevertheless, we need to send them home. We've decided to close the workplace, or the need for labor has reduced and we're sending them home and they don't qualify for other leaves. What's a good strategy here? First of all, and I think this is happening all over, where managers are trying to determine who can reasonably telecommute. The public health officials, I think, in the CDC are both recommending as many people who can telecommute as should. So first, determine if an employee can telecommute. If an employee can telecommute and chooses not to, that is a scenario in which the employee probably needs to be using their own banks in some manner. So you may authorize a leave of absence, and you may require that they draw from their banks. And if they have no banks, that they would be in an unpaid status. However, if an employee cannot telecommute based on the nature of the work or based on the technical capacity of the employer, here are some thoughts for that scenario. So first, if they cannot telecommute and their workplace has been closed by order of a public official for a health reason, then we're going back to the Washington state sick leave. They may be able to use their own state sick leave. They could access shared sick leave pools for that reason. The fact that a workplace has been closed or quarantine has been required by a public health official, let's say an outside entity, the county or the governor says you must close down all city halls, does not necessarily trigger an ongoing obligation to continue to pay full wages and benefits. And we see that in the fact that the federal government is working on this bill, and this bill is explicitly addressing both private and public sector employers. So there would be no need for this bill if there was an otherwise a legal obligation to pay full wages and benefits when workplaces have to be shut down. Because it's not a requirement, it's important to think through what are the forms of leave already available, and then do we as an employer want to consider adopting some form of new paid leave? Some options might be, well, let's offer to front load sick leave. So for employees who are currently employed, we're going to front load your sick leave accruals for the rest of this year, and you'll be able to access them now. And when you come back, you'll essentially reload that bank through your work time? Or do we want to recognize and acknowledge a form of short-term paid administrative leave, perhaps for those who cannot telecommute and otherwise cannot access their sick leave, or perhaps anyone who cannot telecommute? There's considerable discretion, but it needs to be done in advance. For employees who are exempt, paid on a salaried basis, if the person cannot telecommute, they do need to be paid for any full work week if they perform work during that week. And that is because salaried staff receive the same amount of pay for every work period under the Fair Labor Standards Act, and that amount cannot be reduced based on the quantity of work. Final comment here is just if there are union represented employees who cannot telecommute, you might get a request to demand to bargain the impacts of a closure by the union, and that would provide an opportunity to have those discussions and identify alternatives. Next slide, please. So when you come to telecommuting, what are some best practices here? First of all, I think it's essential that you have a written policy that applies generally, as well as individual written plans for individual employees. It's critical for both the policy and the plan to be very clear that it's solely within the discretion of the employer to authorize, modify, and revoke at any time for any reason. Either in a union environment or also thinking ahead to future requests for accommodation of disabilities, it's important to be careful about establishing some kind of precedent. So would be a best practice to have some language in there stating something about this is an emergency circumstance, right? This is authorized because of these circumstances. You may not be able to perform all of your essential job functions while working remotely. And that second sentence is important because under the Americans with Disabilities Act, if an employee in the future requests an accommodation to work from home, if we have previously determined they can do all of their essential job functions from home, it can kind of put the employer in a bind and force them to grant requests when in fact that's not a job that all the essential functions can be done adequately from home. The next bullet here, which states you cannot require telecommuting if an employee is entitled to use protected leave. This is just an acknowledgement that just like any other type of work, if an employee is authorized to be gone on FMLA or the paid family medical leave program or any other statutory entitled leave, then they can't be forced to work, whether they're forced to work at home or forced to work anywhere else. If they're on a legally protected form of leave, they cannot be required to work. Also for telecommuting, if you have those those hourly non-exempt employees, it's essential that they're paid for all time worked. It's essential that they follow any meal and rest break requirements from state law or from a collective bargaining agreement. You need to give that direction to them in advance and be very insistent that they accurately record all of their work time. Salaried employees, again, need to be paid for a full work week if work is performed during that week. All right, next slide. Okay, what about a healthy employee who refuses to work? Let's say your work site is still open and you've taken steps to ensure social distancing and all the other best practices and following all the requirements, and you have an employee who just doesn't come in, refusing to come in to work. The first question is, are there any forms of protected leave available to that person? So do they have a situation where a child is home because the school has been closed? Is that a source of protected leave for them? If it's not, I think you then move to asking the question about, is this an employee with some other health condition that needs to be accommodated? So is this an employee who may have such severe anxiety or other sort of mental health challenges that they could request FMLA, for example, that this is such an anxiety-producing prospect that they could be approved for leave, or they could have a disability that would be accommodated in that manner. The same for an employee who might have an autoimmune disorder. We might be in a situation where we need to accommodate those health conditions by allowing a leave of absence, and that employee then would be able to access their paid leave banks. Question about disciplining employees who refuse to come to work. Clearly, for any union represented employees, the standard for discipline is likely to be just cause. Arbitrators are going to take into very serious consideration what the facts and specific circumstances were. And under the circumstances as they are today, I think it would be difficult to, in many cases, sustain the highest form of discipline in the sense of termination for an employee who reasonably has a concern about safety. So the inquiry would be very, very fact specific. And I think an arbitrator would look very closely at an employer who fired employees because of a safety concern. All right, next slide. Okay, last but not least, I'm just going to touch briefly on the duty to bargain. So public employers in Washington State have an obligation to bargain with unions that represent their staff. The duty to bargain applies to wages, hours, and working conditions. Under the circumstances that we're dealing with today, a couple things just worth noting. So I would say there's no duty to bargain implementing CDC and local health department workplace recommendations. I think both the PERC and any kind of labor arbitrator are going to view those as essential business necessity matters, essential to workplace safety. We would also include in that category the decision to suspend operations. The PERC has been fairly supportive of that as a managerial decision, I think specifically and especially during the current circumstances. On the other side of this chart, the duty to bargain with unions, I think it's good to keep in mind new forms of paid leave, new working conditions such as front-loading sick leave or telecommuting policies, as well as the impacts of changes on the side of the sheet. Likely do trigger a duty to bargain. Now unions are going to be looking for ways to help their members stay safe and continue to receive their wages and benefits. So they're unlikely to be difficult to negotiate these kinds of topics with, but it's good to just keep that in the back of your mind. And then finally, at the bottom of this slide is just a note that as with any duty to bargain, the Public Employment Relations Commission does recognize something called business necessity as a defense to the duty to bargain in a critical scenario where the public health and safety was required to be safeguarded through some action. I would say, you clearly need to put the public health and safety first, and the Public Employment Relations Commission does acknowledge that as a defense. Okay, and I think that's it. One more slide, just with a couple of resources in the employment arena. First is the chart I mentioned that shows state benefits, which is a little bit of a moving target, so you want to make sure you're looking at the most recent version of that one. The second is a reminder of Washington state leave laws. The third is a publication by the U.S. Department of Labor regarding the FMLA and COVID-19. Again, sort of explaining that it's not necessarily a serious health condition, but that otherwise the FMLA will fully cover employees who do become that ill. The EEOC published a pandemic preparedness guide a number of years ago. You're seeing that reference there. And then finally, there is a guidebook by OSHA on the virus as well.
Okay, thank you, Sophia. This is Flannery Collins from MRSC speaking now. We're going to turn now to remote meetings and emergency meetings of the legislative body. So a lot of local governments are now exploring this option of remote meetings of the legislative body to minimize crowds gathering in the council chambers and other similar public meeting spaces. Now, this is absolutely the prudent approach given the virus's rapid spread. The Attorney General's office issued specific guidance on how to hold public meetings during the coronavirus situation, and that guidance is available as an attachment in the toolbar. So let's turn now to the basis of that guidance. In 2017, the Washington State Attorney General's Office issued an opinion which concluded that yes, legislative bodies can meet remotely by phone, computer, or similar means. But the AGO opinion makes a critical caveat, which is that the meeting cannot be 100% remote. There has to be a speaker placed in a designated meeting space so that members of the public can hear all discussions and generally observe the steps employed by the legislative body in taking its official action. And the basis for this designated location requirement is that, first of all, members of the public must be permitted to attend public meetings. And second, the agency cannot place conditions on attendance. And that's in RCW 4230-040 in the Open Public Meetings Act. Now, many agencies are worried about this last requirement to have a designated location where the public can listen to a remote meeting of the legislative body. The AGO opinion that was referenced in that last slide was issued in 2017. It didn't really address the situation we are in now, where even having a physical location where the public can listen to the meeting may pose a problem, especially given the increasing restrictions from the state on public gatherings. The Attorney General's Office did, however, as I previously noted, issue that recent guidance specific to holding meetings during the coronavirus outbreak. And it really does help agencies think through these issues. So I'm going to go over some of those considerations now. The first is the agency should really ask itself, does it really need to hold a meeting? Take a very close look at whether the legislative body needs to meet at this time. Can the meeting be postponed until the virus is more contained? And think about, what may have been important 2 weeks ago to meet about may no longer be important given the state of this public health emergency. Second, if the agency does need to hold the meeting, ask whether the number of agenda items can be reduced to only those ones needing immediate attention by the legislative body. So the third thing to think about is, in addition to finding that, providing that physical location, you really should be pushing alternative remote means for the public to attend. So whether that's a call-in number, real-time streaming over the computer, joining via GoToMeeting, or some other option the public can choose in lieu of attending at the physical location. Once the agency determines which remote means it will use, post that on the agency's website and all of your other meeting notices. So put the dial-in number or other remote connection information specifically in your notices of the meetings. So in addition to including how to access the meeting, you should also be ensuring that your notice includes the latest restrictions on crowds gathering. So it's now at 50 or more. That's a prohibition now on crowds of 50 or more gathering, as well as complying with social distancing before attending the meeting. So in your notice, you'll provide that latest restriction so individuals can check to make sure they understand what the mandate is from the state at this time, or the county, as the case may be. And so what you'll do then is you'll strongly encourage attendance by remote means. So one word of caution here regarding remote meetings, think about which remote meetings are the best to choose, because you shouldn't be choosing a remote meeting option that requires members of the public to identify themselves, because under the OPMA, the public cannot be required to identify themselves just to attend a public meeting. Now, there are some issues with the physical location requirement that I think could arise here. So first, does the agency even have a location where the social distancing can be accomplished? In other words, if you only have a small office or your meeting chambers are too small to accommodate the social distancing directive, what are the options here? Or what if a staff member has been diagnosed with a virus at City Hall, for example, and let's say the City Council still needs to meet to handle urgent business? What are the options? If there's a case of COVID-19 at your agency, you'll likely be shutting down the building for some period of time. So our best guidance in these types of situations, if they arise for your agency, are first and foremost, work very closely with your legal counsel on how to proceed in the spirit of the OPMA. Options would include, first, finding an alternative location to locate the speaker for the public to attend the meeting. Second, if you cannot find an alternative location, then take a hard look at whether the meeting needs to take place. If the answer is yes, then provide every means possible for the public to attend remotely, by phone, by computer, by streaming, by public access channel, and then take only necessary action at the meeting. But I just want to alert individuals at this point, if you do not have a physical location where the public can access the meeting, there could be some OPMA risk in proceeding with the meeting. On that note, though, I will add these are unprecedented times and the guidance continues to evolve in this area. So please continue to check our site, the governor's site, and the Attorney General's site for any updates in this regard. With the increasing restrictions on public gatherings and social distancing being implemented by the state, the guidance will continue to evolve, and we do expect to receive further guidance from the state on this particular issue. So let's now turn to public comment. So if the legislative body is meeting remotely and there is a phone or a computer in the physical space where the public can attend the remote meeting, then I think there are probably two options for accepting public comment. The first would be that written comment should be submitted before the meeting, and that's probably the best option. But the second option would be if you have a staff member present at the physical location, public comment for those present at the physical location could be treated just as it would during a normal in-person public meeting. The only difference is that the individual would be speaking into the speakerphone or computer. The staff member would have the speaker sign in, would unmute the speakerphone or computer, and then would monitor the speaking time as would normally occur at an in-person meeting. Now, for those members of the public who have chosen not to attend in person, but instead are joining the meeting remotely, I think it would be pretty difficult for the agency to allow public comment of those individuals during the meeting. But this is an area we will continue to look at and explore, given that this may be the new normal for of remote meetings for the next month or so. Let's hope it's the next month or so. And just a reminder here, the OPMA doesn't actually require the agency accept public comment at general public meetings. But I did also want to address public hearings, which are different from public meetings, because the intent of public hearings is really to obtain that public testimony or comment before a significant decision is made by the legislative body. So examples of these can include budget hearings, review of the comprehensive plan, or a hearing on a moratorium or interim zoning ordinance. And there really is no question about it. Public hearings are geared towards in-person meetings. It would be a real challenge to hold an effective public hearing and take public testimony remotely. Your agency would really want to take a look at the urgency of the matter and postpone the public hearing until it could be held in person. If this is absolutely not possible, your agency would need to be creative in how to accept public comment, since the whole point is to provide an opportunity for all attending members of the public to speak if they so desire. So again, we'll be exploring ways that you can meet remotely and provide that opportunity for public comment, and we'll post any information on our webpage. I wanted to say a quick bit here about emergency meetings of the legislative body. The OPMA does allow an agency to skip the 24-hour notice required for a special meeting if there is an emergency and there is a need for expedited action by the governing body to meet the emergency. But the agency really needs to ask, is it really the agency's emergency? If it is, then there is no notice required for that emergency meeting. But if it's just kind of a general emergency, like the state of Washington in a general emergency situation, and it's not that agency's particular emergency, an emergency meeting may not be appropriate. So that actually wraps up the substantive part of our webinar today. I did want to highlight a couple resources. The MRSC webpage, we have a webpage dedicated now to COVID-19. We are continually updating that webpage with new information. So please continue to check back there frequently for new updates. And before we close this webinar today, I want to extend a very big thank you from MRSC to both Jamie Lissagore from Pacifica and Sophia Maybe from Summit for providing their invaluable insight on this public health issue. Due to this rapidly evolving situation, MRSC organized this webinar in a very short time frame so that we could get this information out to Washington local governments as soon as possible. And Jamie and Sophia graciously agreed to participate in this webinar with less than a week's notice. So thank you very much to both of you. And I want to thank those of you who listened in today. We hope you found this information helpful as you move forward with your public health emergency planning. So with that, we'll be ending the webinar. Thanks again and take care.